Someone might not understand. We could turn around and just stay quiet. But if we're quiet, they won't know.
Welcome to the Mindanao State University College of Law Legal Forum 2035. And for this legal forum, we'll be tackling up remedial law. As the term itself suggests, provides for the remedies and the procedures to be observed by way of enforcing rights and obligations. And this includes the new rules of courts, the civil procedure, the provisional remedies, special civil actions, special proceedings, criminal procedure, evidence, and the rules concerning admission to the practice of law, which will be discussed by our four distinguished speakers who are actually alumni of our own Mindanao State University College of Law. They are now expert lawyers, and for that, let's all listen to them. So good day, I am tasked to discuss all about civil procedure. And when we say civil procedure, it treats the enforcement and protection of rights in civil cases. And there are two kinds of civil action. The first one is the ordinary civil action, which includes collection case, abatement of nuisance, and breach of contract. And the second one is the special civil action, which includes foreclosure of mortgage, interpleader, eminent domain, quo warranto, certiorari, and more. Now let's move to the provisional remedies, and they are the remedies which may be availed of by the petitioner, which are temporary in character because they are subject to some modifications that may be ordered when judgment is finally rendered. This actually has There are five provisional remedies, which includes attachments, the preliminary injunction, receivership, replevin, and lastly, the alimony of pendent light.
So what is special civil action? So it is an action whereby one party sues another to enforce or protect a right or to prevent the commission of a wrong with the following special rules of procedure. The special civil actions are shown in your screen. Interpleader, it is a special civil action whereby a person who has a property in his possession or an obligation to render wholly or partially without claiming any interest on that subject matter comes to the court and asks that person who claimed the said property, personal property, or who consider themselves entitled in order to determine who is entitled to the same. Declaratory relief. It is also a special civil action instituted by any person interested under a deed, will, contract, or any written instrument or whose right are affected by a statute, executive order, or regulation, or ordinance before breach of violation. Certiorari, prohibition, and mandamus. These are special civil action directed against any tribunal, board, or officer exercising judicial functions. Shown in your screen are the differences of the three. Quo warranto. It is also a special civil action whereby a person claiming to be entitled to a public office or position files an action against a usurper challenging the authority of the latter in holding said public office or position. And here are the kinds of quo warranto. Eminent domain. It is the right of the state or any duly authorized entity to take private property for public use or purpose, provided just compensation is given and due process is observed. Closure or mortgage. It is the process by which the mortgagee creditor is allowed to have the mortgage property foreclosed and sold in order that the indebtedness may be paid out of the proceeds of said sale. Partition of real estate. It is a process of dividing or assigning property owned in common among the various co-owners thereof in proportion to the respective interests in the property. Partition may be done judicially or extrajudicially. The partition of property may be done by agreement or compulsory under Rule 69 of the Revised Rules of Court. Forcible entry, it is a special civil action whereby a plaintiff prays for the recovery of material or physical possession of real property because he was deprived of his possession thereof by force, intimidation, strategy, threat, or stealth. Contempt. There are two classifications of contempt. First is direct contempt, and the second one is indirect contempt. Contempt may also be classified into criminal contempt or civil contempt, as shown in your screen.
This time, let's proceed to special proceedings. Special proceeding is a civil remedy taken to establish the status or right of party or to establish a particular fact. The special proceedings are as follows. First, settlement of estate of deceased person, which can be summarily settled in two ways: through extrajudicial settlement of estate by agreement of the heirs, or through summary settlement of estate whose gross value is 10,000 pesos or less. Next, petition for probate of will and issuance of letters testamentary. Probate is the process of proving before a competent court that the will of a deceased person was duly executed, and that the said decedent possessed testamentary capacity at the time of the execution of the will. And when all these are proved, the will of the descendants shall be submitted for approval of the said court. Petition of letters of administration. Petition for escheat. Escheat is a special proceeding whereby the real and personal property of a person who dies without a will or in any legal heir becomes the property of the state upon his death. Petition for guardianship. Petition for appointment of trustees. A trustee is a person appointed by the court to carry out the effect of the provisions of the will and the one who holds the trust for the benefit of another. Petition for adoption of minors. Petition for hospitalization of insane persons. Petitions for habeas corpus. Habeas corpus is a remedy to relieve persons from unlawful restraint. Petition for change of name. Petition for voluntary dissolution of corporation. Judicial approval of voluntary recognition of minor natural children. Petition for judicial constitution of family home. Petition for appointment of administrator and or trustee for the estate of absentee. Lastly, petition for correction of entries in the civil registry.
Hi, let us proceed to criminal procedures. So what is criminal procedure? It is a part of the remedial law that provides for the apprehension, prosecution, conviction, or acquittal, as the case may be, of a person who is accused of having committed a crime. In order to conclude our criminal procedure, we must identify the criminal jurisdiction first. So what is criminal jurisdiction? It is the authority to hear and try a particular offense and impose the punishment for it. There are two elements of jurisdiction in criminal actions. The first one is the nature of the offense and or the penalty attached thereto. The second one is the fact that the offense has been committed within the territorial jurisdiction of the court. Remember, these two must be present or else it may be challenged by the accused that may cause for its nullity or void. So how do criminal actions commence? There are two ways. The first one is by complaint. The second one is by information. To differentiate, the complaint is a sworn statement charging a person with an offense subscribed by the offended party. Offended parties such as peace officer or enforcement officer, or as the case may be. By information, on the other hand, is a written statement of accusation charging a person with an offense subscribed by a fiscal. In a nutshell, the stages of criminal procedures are: the first one is the prepare for the case, the second one is the preliminary investigation, the third one is the filing of information or the complaint, the fourth one is the arraignment, the fifth one is the pre-trial, the sixth one is the trial, the seventh one is the judgment, the eighth one is the appeal, and the last one is the execution.
And we are now down to the last two, number 6, evidence. It is the means sanctioned in the rules of ascertaining in judicial proceeding the truth respecting a matter of fact. This includes documentary evidence, testimonial evidence, real evidence, circumstantial evidence, corroborative evidence, cumulative evidence, prima facie evidence, expert evidence. And then lastly, the rules concerning admission to the practice of law. According to our Constitution, the 1987 Constitution, Article 8, Section 5, the Supreme Court shall have the following powers: promulgate rules concerning pleading, practice, and procedure in all courts, the admission to the practice of law, and the integration of the bar, which, however, may be repealed, altered, or supplemented by the National Assembly. Such rules shall provide a simplified and inexpensive procedure for the speedy disposition of cases, and shall be uniform for all courts of the same grade, and shall not diminish, increase, or modify substantive rights. So that's all. Thank you. And that concludes our Legal Forum 2035. I hope all of you learned from our guest speakers. For more queries, please refer to the book Introduction to Law by Rolando Suarez. So, have a nice day. Bye!
Okay guys, magsugod na ta. Ay hala, wala pa si Sir Glenn?
Ay, wala pa. Ay, na siya. I-admit na ako, ha?
Ah, sige.
Ano siya?
Hi Sir Glenn.
Uy, manok sa inyong part sa intro to law?
Hala.
Monday na biyan deadline na to.
Sorry, Jupa. Ikaroon ba, Jupa, ka matapakawanan ba siya kay gadamong ko nga kitang upat. Speaker daw ta sa legal forum sa MSU College of Law nga kuan sa 2035.
Wow.